Testing, testing. Amanda, can you hear us? Amanda, can you hear us?
Yes, I can hear you. Can you hear me?
Yep. Okay, great. Thank you.
Okay, welcome to the Maryland Public Service Commission's hearing in case number 9773, the matter of PSE&G Renewable Transmission LLC application for a certificate of public convenience and necessity to construct a new 500 kV transmission line in portions of Baltimore, Carroll, and Frederick counties. I'm Fred Hoover. I'm the chair of the Maryland Public Service Commission, and with me is Commissioners Bonnie Sushman, Obie Linton, Mike Richard, and Kumar Barve. So let me first start by taking appearances for those parties that we've granted intervention. And I guess let me start with the applicant, PSE&G.
Good morning, Your Honor and Commissioners. Joseph Curran, appearing on behalf of the applicant, PSEG Renewable Transmission. I'm also joined this morning to my left by my co-counsel, Christopher Gunderson. At this time, I'd also like to enter the appearance of more of our colleagues, Susan Schipper and Ananya Sinha, both of our law firm at Venable. We have also petitioned and received acceptance for admission to the state of Maryland for the limited purpose of appearing in these proceedings for Jody Moskowitz, who is Deputy General Counsel of PSEG, and Anna Merteri, who is also counsel for PSEG, and would like to have their appearances entered on behalf of the applicant as well.
Okay. One technical thing, if you could either pull whatever mic you have closer to you or maybe speak up just slightly as we're going forward. So, okay, so let me next turn to the Power Plant Research Program.
Good morning, Chair Hoover and Commissioners. My name is Sandra McLemore, Assistant Attorney General, representing the Power Plant Research Program. Also, I'd like to enter the appearance of Stephen Towson, an Assistant Attorney General for the PPRP as well.
Okay. Baltimore County.
Good morning, thank you. Attorney Lisa Smith on behalf of Baltimore County.
Carroll County. Going once, going twice. All right.
Good morning,
Mr. Chairman. Maloney,
County,
Timothy
Carroll
Maloney,
County.
County, and joined by County Attorney Timothy C. Burke.
Okay.
Thank you.
Frederick County.
Hello, Wendy Kearney, counsel to Frederick County, and County Attorney Brian Black is here with me, as well as Assistant County Attorney Joshua Brewster.
Stop MPRP.
Good morning, Chairman and Commissioners. This is Carolyn Elephant. I'm counsel for Stop MPRP, and I believe that Joanne Frederick, president of Stop MPRP, is also on this call somewhere, though I can't see her on the screen.
Okay. Maryland Farm Bureau.
Good morning, Chairman and Commissioners. This is Susan Eitenayer. With me is Randall Lutz and Anastasia Topaltzis. We represent the Maryland Farm Bureau in participation with Frederick County Farm Bureau, Carroll County Farm Bureau, and Baltimore County Farm Bureau. We also represent, if I can go ahead and
Sure.
enter these appearances as well, the Land Preservation Trust Incorporated, Arnold Developer Associates, Inc., and Jesse Smith, LLP, Dwight Bogger and Bogger Enterprises, Incorporated, Michael and Lisa Gaver and Gaver Farm, LLC, John and Robin Cable, Wakefield Farm, LLC, also associated with that, the John Alder Cable Trust and Robin Smith Cable Trust. Number 7, John and Donna Reese and Broadview Farm, LLC. And number 8, Jane Shaw, Rockland Farms Incorporated, and Jane Shaw Revocable Living Trust. Several of our clients are available as well, and they are participating remotely.
Okay, thank you. Potomac River Keeper Network.
Good morning, Your Honor and Commissioners. My name is Morgana O'Malley of Chesapeake Legal Alliance, appearing on behalf of the Potomac Riverkeeper Network. I would also like to enter the appearance of my colleague, Patrick DeArmy. Thank you.
Gunpowder Riverkeeper.
Good morning, Commissioners. John Mueller with the University of Maryland Environmental Law Clinic, representing Gunpowder Riverkeeper.
Okay. Hattery Farm LLC.
Good morning, Mr. Chairman, Commissioners. Margaret Weatherup on behalf of Hattery Farm LLC. I'd like to also enter the appearance of Carla Weber. And we also represent Monocacy Investments LLC and Deborah M. Hattery as trustee for the Hattery Family Trust, who has not yet been admitted as an intervener, but that is one of the requests we'd like you to consider today.
Sure. Todd Jones Prettyman.
Hello.
Yeah, go ahead if you're.
Can you hear me?
Yes, I can hear you now. Yeah.
Yeah. All right. Sorry, I'm on a charter bus, so I apologize. I believe you called Todd Jones Prettyman, correct?
That's correct.
Correct. All right. I'm Todd Jones Prettyman. I've not yet been admitted as an intervener, but I represent myself and my wife, Jacqueline Crawl. Thank you.
Okay. John W. Lewis.
Good morning, Commissioner and Chairman. My name is John Lewis, and I'm pro se, representing myself.
I see. Okay. Carolyn Castillo.
Good morning, Commissioner. My name is Carolyn Jamela Castillo, and I am per se representing myself.
Prashant Pashal. I may have mispronounced that, so.
Prashant Panchai.
Yeah.
Well, so much for my uses.
All right.
May I introduce myself, Commissioner?
You are?
Yeah, my name is Jeff Sprinkle, Carroll County. I'm representing the Shipley family and farm on 1301 Balker Road, so representing my family and everyone involved.
Okay. Jennifer Teeter and William Frank Baylor.
Yes, good morning. This is Jennifer Teeter.
Okay. Matthew and Chantel Mosellen.
Yes, hi, this is Chantal Masellan, and I am representing myself and my husband, Matthew Masellan.
Okay. River Valley Ranch LLC.
Good morning, Mr. Chairman and Commissioners. This is Jennifer Wazensky representing River Valley Ranch and Peter and John Radio Fellowshipping.
Dell Generation Farms.
Good morning, Attorney Mike Hinkle for Dell's Generation Farms LLC, Matthew Dell, and Francis and Marion Dell.
Heidelberg Materials, U.S. Cement.
Good morning, Mr. Chairman and Commissioners. Matthew Graham of McNeese Wallace and Eric LLC, representing Heidelberg Materials, U.S. Cement LLC.
All right. Office of People's Counsel.
Good morning, Your Honor. Brock Miller on behalf of the Office of People's Counsel. I would also like to enter the appearance of David Lapp, William Fields, and Michael Sammartino.
Office of Staff Counsel.
Good morning, Chair Hoover, Commissioners. Lloyd Spivak for the Commission staff. I would also like to enter the appearances of Michael Dean and Jennifer Purvis.
Okay, so that is everybody that is on my list. So if you were not mentioned and want to enter your appearance, raise your hand and we'll recognize you. don't see anyone, so. Wait a minute.
My name's Brandon Hill, and I'm representing myself pro se. I'm raising my hand. I guess. You
Okay,
can't-
that's fine. Yeah, it is a little hard to. Okay. Anyone else?
Hi, my name is Lisa Wright. I'm representing myself and my husband Justin Wright.
Okay. Anyone else?
My name is Charlie Bond, representing myself and my wife, as homeowners, pro se.
Okay. Anybody else?
My name is Pat Wilmson. I'm representing my father, Dan Strickler.
Can you spell your last name?
Wilmsen.
Okay. Anybody else? Okay. Now, so we issued an order granting intervention for a number of parties, and then provided an opportunity for other parties who we initially listed as interested parties and gave them the opportunity to request intervention as a party. The one that I'm familiar with is Hattery Farms LLC. We're granting them intervention status. And is there anybody else on that list? Which one?
That's correct, Your Honor. Did you want to hear from,
No,
on behalf of Deborah M. Hattery?
No, actually, you're fine. We've granted your petition for intervention. So, and same for the Prehearing party. Which one? And do we have? Oh, and then same for the Jennifer Teeter and William Frank Baylor. So all three of them are now parties as interveners. Is that everybody? Okay, now let me turn back to the applicant, and why don't you deal with the process things we have to deal with first, and then we can talk about the schedule.
Great, Your Honor. We do have some housekeeping that you had were referring to. I assume it's the certificates of publication that were published in both.
Yeah, actually, Mr. Kern, you're going to have to, again, either pull the mic a little closer or speak a little louder, because we're actually having I mean, we hear you, but not really good enough, quite honestly. So.
Okay, how about now?
A little bit, but again, speaking on a loud octave.
I'll keep my voice up. It
Okay.
might,
Fair enough.
drive my colleagues crazy here, but I'll keep my voice up.
Okay.
Your Honor, we do have some housekeeping, limited housekeeping in connection with certificates of publication. We'd like to first identify the certificates of publication for notice of intervention deadline, in this case, in which the applicants filed on February 7th, 2025. Your Honors, those are mail log, that is mail log number 315587. And it's the certificates that we filed in February. We would like this marked for identification as applicants Exhibit 1.
So marked.
Okay. The next exhibit, Your Honor, is the certificates of publication for the notice of this pre-hearing conference in which the applicants filed with the commission on June the 6th, 2025. The mail log number for that, Your Honor, is 319491. And Your Honor, we would ask that this be marked for identification as applicants Exhibit 2.
So marked.
Both of these exhibits contain statements certifying that the applicant complied with the commission's notice and copy service requirements for the CPCN application set forth in COMAR and in the Public Utilities article. And if there is no objection, Your Honor, we would ask that applicants' exhibits 1 and exhibit 2 be moved into the record.
So admitted.
That's the only housekeeping matter we have, Your Honor, and obviously you are prepared to discuss the other preliminary matters that the commission has identified for this morning's pre-hearing conference.
So, yeah, let's go ahead and move on to the filings you made regarding the schedule.
Thank you, Your Honor. First, I'd like to note for the client that we appreciate the commission scheduling today's pre-hearing conference. Obviously, based on the filing and on the number of interventions in this case is of significant importance to Maryland and to the regional transmission grid in order to prevent serious and widespread forecasted reliability violations that are projected in June of 2027. We filed earlier this year, Your Honor, a motion for adoption of a procedural schedule back in March of this year. We updated that recently on June 6th just to reflect the realities of where we are in this procedural matter. We would, I guess, really want to focus, Your Honors, on the importance that a full procedural schedule be adopted. This is very similar to what the commission did in the TransSource matter, which is one of the more recent greenfield applications that was considered and reviewed and ultimately approved by the commission. And the reason we're seeking a full procedural schedule and not a limited procedural schedule is really twofold, Your Honors. One, it is essential for planning purposes, both for the company, but for PJM as well. Knowing a full procedural schedule, how the commission will evaluate not only our application, but the testimony and exhibits that are presented by the interveners, including the PPRP. Knowing a full schedule and having a full schedule is essential for both ours and PJM's planning purposes. Also, we have presented to Your Honors in our most recent procedural schedule a schedule that will allow the applicant to meet this very important in-service date. And if Your Honors have questions regarding that in-service date, we do have available today PJM if the commission has questions of it. We fully understand that today is not the day to debate the merits of the application or comments regarding the substantive filings in this case. But if the commission has questions about the vitalness and the importance of meeting this service date, PJM is available today to answer those questions. We have, who is a witness in this case, Dr. Sami Abdus-Salam, who is one of the heads of PJM's planning department. And should you have questions, he is available here to answer them. Again, we understand that we're not discussing the merits, but to the extent that you have questions about the in-service date and meeting that important date, they are here. There are really two issues that are driving, Your Honor, our proposed procedural schedule. And you've gotten a lot of information from the interveners, but in particular from PPRP. And you would ask them to evaluate and review our application filed back in December for completeness. And the reason I'm raising completeness is because obviously that has an impact and has been asked to have an impact on our procedural schedule. And in PPRP's letter, they identified two major issues that would impact a procedural schedule. The first being concerns, quite frankly, not so much about the completeness of our routing study, but they wanted to gain a better understanding of the underpinnings of that study. Back in March of this year, in response to PPRP's concerns about the routing study, we presented PPRP, the parties, and this commission with a fulsome description of how our application and how our routing study addressed those PPRP concerns. What the commission has not seen is over the last several months, the parties have been engaged in a robust discovery, mostly from PPRP, but a significant amount of discovery from your staff, the technical staff. A lion's share of that discovery has been about the routing study. Those discovery responses, as you know, we don't file discovery with the commission, but all of the interveners that you have granted intervention or party status to, they now have access to our data room and are able to review those data responses. So we believe that while PPRP raised concerns about the routing study, that we have fully addressed both those concerns through our submission to this commission, which was attached as Exhibit B to our March filing, or March motion, but also through the discovery process and through our meetings and conversations with PPRP. The other significant issue that you're to be well aware of that's driving procedural schedule is field studies. The PPRP has asked that we conduct field studies to validate the government-sponsored government data that we have assembled in the development of our schedule. Those field studies, it is our contention, your COMAR provisions do not require field studies to be a part of the application. None of the COMAR that's guiding the filing in this case actually require field studies in order to be, or in order for an application to be deemed complete. Nevertheless, we fully understand and appreciate PPRP's request for that information. And as the commission may be well aware of, despite months of efforts, quite frankly, to obtain access to the landowner's property that is the subject of our route, we have been denied most of that access. And as a result, required the applicant to pursue rights of access in Maryland's federal district court. Those proceedings are underway. Those proceedings have been argued at the federal court. They've been vigorously pursued both by the applicant and by the landowners who have refused the entrance. We can report to you today that that case is fully briefed and we are awaiting the outcome. Nevertheless, despite the fact that COMAR does not require field studies, we have every intent through the discovery process in this case, Your Honors, to pursue those field surveys. And when and if we are provided access to those properties, we will provide that information to PPRP and to the other parties in this case who have all, in their comments and filings, suggested that that is an essential piece of information for their review. Our core argument in the commission today is we should not delay the development of a procedural schedule that allows two things to go on concurrently. One, your review of our very robust CPCN application while at the same time we pursue through discovery and through the discovery process, the field surveys that PPRP has requested. This is very similar, quite frankly, to what was done in transfer. The commission developed and ordered a full procedural schedule with dates for testimony, rebuttal testimony, surrebuttal testimony, scheduled evidentiary hearings, as well as briefing. That all happened concurrently with TransSource efforts to obtain the field surveys that PPRP requested. So while we have a somewhat of a very important semantical difference with PPRP over the interpretation of your COMAR provisions on what is a full application and what is required by your COMAR, and what we fully acknowledge and are making every effort to obtain field level surveys so that we can present that to PPRP. What we want to impress upon the commission, however, is the materials that you have reviewed in our very significant environmental review documents, as well as the materials that support our line route, are all government-sponsored data that we've been able to get from folks like the NR and other state agencies, as well as federal agencies, that have the job, quite frankly, of accumulating this data. We've pulled that together, and that was the foundation of our line route examination of alternatives, as well as our preferred route. That information has been available to the parties since our December filing. And we will continue to strive to get the field level service data that is really for the purpose of validating the vast amount of government issued data that supports our application. So we have every intent of getting that, but what we're asking the commission to do today is allow both of those things to go on concurrently. To define a procedural schedule that addresses the issues, both the need of this case, as well as the citing issues. And quite frankly, our proposal is to allow for, quite frankly, to relieve some of the burden on the commission to segregate both the need case, which is supported by PJM witnesses, from the citing testimony. And believe that that proposal would allow the full evaluation of the case without overburdening the commission of having all of that testimony and responsive testimony filed at one time. That was really the nature and the underpinnings of that suggestion to the commission. So we are asking, Your Honors, in our motion, that the commission adopt a procedural schedule consistent with the dates in which we presented to you that would allow us to have a final order on this case by March of 2026. That would allow over 15 months of commission evaluation of our application, which is not inconsistent, quite frankly, with other CPCN applications. I'm not under any illusion, however, that this is the typical CPCN case, and that is demonstrated by the vast number of interveners that are here today and parties that have expressed an interest in this case. However, nevertheless, every CPCN case is evaluated on its own merits and based on the unique circumstances of each of those CPCNs. In this case, we're confronted with what has been presented to us and what's been presented to the commission as very serious, widespread violations that are forecasted to occur as soon as the summer of 2027. And that's really the date. Unlike other CPCN cases in which the commission has been able to manage, that's really the date and the issue that we are confronted with as a developer and as the parties in this case. Having said that, we have tried to present to you a procedural schedule that we've asked you to give consideration to that allows the parties to engage in fulsome discovery, which has already commenced, quite frankly. I can reveal to the commissioners today that the applicant has already answered over 300 pieces of individual discovery on this application that has ranged from the need on this case to our siting and routing analysis. That's been underway since we filed and will continue. And we've proposed a discovery schedule for other parties in order to engage in questions of our application. So that is really our request to Your Honor, is the importance of this case is evident. The reliability violations are supported and sustained in our application from the regional transmission organization that is tasked to maintain the safe and reliable operation of our transmission system. And we are also understanding our obligation to ensure that the parties in this case have a fair opportunity for discovery and that they can challenge our testimony. It is our burden in this case, and we intend to meet it, and we intend to meet it with the testimony that we have already filed and are happy to support that with additional survey information for PPRP. So, Your Honor, I will rest at this point. We can go through if it's individual dates, but those are really the fundamental issues that are driving this is our June in-service date, and in order to give our folks the sufficient time they need in order to construct this line, which is vital to this state and to this region by June of 2027.
Okay, let me ask one process question before I turn to the other commissioners to ask questions. The schedule that you filed on June 6th, to the best of your knowledge, does that reflect agreement from any other party?
It does not. Okay. I can report to the commission that we shared this with both staff and with PPRP, but it does not reflect any agreement between those parties.
Okay. So let me start with questions from the commissioners. Commissioner Sussman.
Good morning, Mr. Curran. So I wanted to explore a little bit your suggestion that there's a great urgency in our review of the application, and you're telling us that the transmission line has to be in service by June 1st of 2027. Is that correct?
That's correct.
Okay. So let's look at this need that you're suggesting that you have that for us to review this in as quickly a manner as possible. And let's start at the moment you received approval from the PJM board for the project, and that was December 11th of 2023. Is that correct?
That's our understanding, yes.
Okay, you're going to have to speak up a little bit. So that is your understanding.
Your Honor, that's our understanding, correct.
Okay. Well, I mean, this is your project, so presumably yes. you would have more than an understanding. That correct? Yeah. So the answer would be yes. Is that correct?
Correct.
Okay.
That's correct.
All right. So at that moment that you received approval, it was your understanding that this project needed to be built in as quickly a manner as possible. Is that correct?
It needed to be constructed by June of 2027.
Right. So you recognize that you had time constraints and that you needed to get the process moving as quickly as possible. Is that correct?
That is correct.
Okay. So you filed with FERC on April 15th of 2024, and I'm saying you as your client, filed with FERC for a request for transmission incentives. Is that correct?
I'll be candid with you, Your Honor. I'm not their FERC counsel. I'm their Maryland.
Yeah, okay,
counsel.
but I need Mr. Karn, I understand that, but I need an answer to the question. You have multiple counsel with you now. Is there nobody who is a representative of your client that can answer that?
My understanding is that is a correct date for the filing of that FERC pleading.
Okay, so that's 4 months after, actually 5 months after your client received approval of the project. And in that 5-month period, was there any sort of sense that we need to get this thing moving quickly because we have an in-service date of 2027?
Your Honor, in all due respect, that filing does not drive the development of this case. I'm happy to go through a timeline with the commission.
Well, okay. The reason I'm
was done by.
Okay, Mr. Karan, the reason I'm asking is I'm assuming that your client waited for approval of the transmission incentives before they went ahead and filed for CPCN with our body. Is that correct?
No, that's not correct.
Okay, then tell me why.
It's not related to the timing.
It's not related. Okay,
Yeah,
so you could have.
Yeah, sure.
So you could have filed with us even before you filed with FERC. Is that correct?
We could only file. That's the timing of FERC filing is not associated with the filing of the CPCN. We could only file the CPCN until we had a preferred proposed route, and the filing of the CPCN was driven by the timing of the development and review of alternative routes through both a stakeholder process and through our expert routing specialists. The two of them were not related, and the timing of them were not related at all.
Okay, so you received approval of the project, but you didn't have a route at that point.
That is correct. There was a route that was considered but it was not a detailed route, and we needed to go through the detailed routing analysis after we were selected as an approved project.
Okay, so it
Which
took.
is not
Okay,
atypical,
it took a full year from the time that you received approval from the PJM board before you filed with us.
It did.
Okay, and recognizing that at the time that you filed, you essentially gave us 15 months and your proposed procedural schedule for us to approve your project. So you had a great urgency initially when you received the project approval from PJM, because you didn't give yourself a lot of time. PJM board approved your project at the end of December. You said you represented to them that you would be able to have that project in service by June 1st of 2027. Not a lot of time, and yet you waited a full year before you proposed that project with us, so that we ended up only having, in your proposal at the time, 15 months to consider your application. I'm not sensing a great urgency in that 1 year. And in fact, you represented to FERC. You don't know this, but I have your FERC filing, and I'm sorry that you don't have your FERC filing. But I have your FERC filing, and in the FERC filing, you represented that you would be filing with us in the third quarter of 2024, and so you needed them to expedite consideration because that was driving your filing with us. So at least in your FERC filing, the two filings seem to correlate. In that filing, you also talked about the potentially lengthy process that you would be engaging with us in considering the CPCN, and that's why you needed FERC to give you expedited treatment of your proposal, which they did.
Your Honor, all I can represent to you today is what was driving the timing of the CPCN filing was the development of these routes and examination of the alternatives in a very large study area.
Okay, well, you should talk to your FERC counsel because the FERC filing suggested that what was driving that filing was that you needed to file with us in the third quarter of 2024, which didn't happen. You filed at the very end of the fourth quarter of 2024. So I'm still not, I'm not sensing that there was a big urgency in getting that filing to us. So let's go to your proposed schedule that you just filed with us, that you shared with staff and PPRP. Sounds like you didn't share with any of the other parties and didn't work to come up with a consensus schedule. You have a target date of March 31st, 2026, which is different than, I believe I'd seen target dates that were represented to FERC of September of 2026, but regardless, you've shortened the time for consideration for us. You're suggesting a robust consideration on our part. We haven't even begun consideration of this, and you're giving us 9 months to make a decision on a greenfield project. I mean, this is, my understanding is, and we'll have to look at this a little bit further, but my understanding is that that PJM has never authorized a greenfield project of this length, and you're suggesting that we have 9 months from today. We haven't even set a procedural schedule, and you're suggesting that that's going to be sufficient time for us to engage in this robust consideration that you're suggesting we'll be able to do under your timeline.
Your Honor, we fully understand the...
You're going to have to speak up, Mr. Curran.
...that we are asking you to encounter. Fully appreciate it. I can say that this is driven by the very severe and widespread violations that are projected to occur in 2027.
No, Mr. Curran, I understand that that's what you said, but there didn't seem to be a lot of urgency through 2024, and suggestions were made at FERC that seemed to not bear out in terms of what you have done with the current proceeding.
Yeah.
And now you're telling us in your schedule that you think we only need 9 months to consider what my understanding is the longest greenfield transmission line that PJM has ever approved. Now, maybe PJM can tell me that they've approved others, but my understanding is, for the most part, they approve brownfield lines. So I'm just not understanding the great urgency in getting this done in 9 months when you didn't seem to have such a great urgency in getting your filing to us. And Mr. Chairman, that's all I have. Unless Mr. Curran, you have an answer to my question.
Yeah, first of all, Your Honor, thank you for your question, observation, and we fully understand and appreciate your point of view. I would say a couple of things. I'm going to respectfully disagree with you on the activities and the urgencies in 2024. Having been involved personally with this project since the client was identified and approved as one of the Window 3 projects, I can assure this commission, and the record bears out in the testimony, of the amount of substantive, significant work that had to take place, Your Honor, in 2024. Not only with the experts that had to find and identify routes, which is a very time-intensive process to find those routes, making sure that they comply with state law, federal law, and meet the routing requirements, plus to have full public engagement of having public information sessions, which we had in July, which are not in your regulations but should be. But the company went out of its way to make sure it had those public information sessions, not only in July, but in October of that year, in order to make refinements to the proposed route. So as soon as that process was done, a route was ultimately selected in November after a very lengthy process. So it's not as if no work was occurring in 2024. Significant amount of work was occurring. Public was engaged in that, and that would ultimately resulted in a route being finally identified in November of 2024. As soon as that was done, Your Honor, we filed that CPCN application. If we could have gotten it in earlier, we certainly would have. But we will not do that and rush at the expense of making sure that the routing process had integrity, had experts, had public engagement. And if you look at the testimony that was filed in this case by Ms. Schakowsky, by Mr. Kawa, by PJM, that discusses the urgency of the June 2027 date, you'll see that a significant amount of work was done in 2027. So I respectfully and humbly disagree with you on that. If I could have gotten this in earlier, I certainly would have, Your Honor.
Okay,
but I'm not gonna file an application with you all that doesn't meet your requirements.
But Mr. Curran, you understand that now you're asking us to rush our consideration. 9 months is not a lot of time for us to do this proceeding. Do you think that that's a sufficient amount of time for us to give due consideration to all of the issues in play?
Your Honor, I do not want this commission, would never want this commission to rush. All we're asking for is a deliberate schedule that allows for a recognition by the commission of a significant event that is forecasted to occur.
Okay, but Mr. Curran, you're not answering my question. Is 9 months a sufficient amount of time for us to be able to do our statutory responsibility?
If Your Honor, the answer is yes. I would not have proposed a schedule to you that I didn't think was sufficient for you all to review.
So your answer is yes.
Ultimately, that decision is up to you and your good colleagues to determine.
I know, but Mr. Curran, I just need you to answer my question. Is 9 months a sufficient amount of time for us to do our statutory responsibilities?
I believe so, yes.
Okay, thank you. That's all I have.
15 months, Your Honor.
Okay, Commissioner Linton.
Thank you, Mr. Chairman, and good morning, Mr. Curran and council. We were talking a little earlier regarding the filing you made, the proposed schedule, and a response that was filed with the commission on June 9th from the Stop MPRP Incorporated regarding some questions about your proposed schedule. As you commented and mentioned in your original opening comment, there is a concurrent proceeding going forward in the district court for Baltimore regarding access to some of the properties that where this transmission line is going to proceed. According to the filing we received on June 9th, the proceeding in front of the district court is covering only a portion of the properties along the proposed route. What is your plan for the remaining properties?
Commissioner, thank you for that question. The initial submission of property right of entry petitions is associated with properties that potentially have limitations or time of year restrictions on when you can do certain RTE, rare and endangered species reviews. So we made those a priority. Certain fauna that are have been identified as rare and endangered. Those properties have the highest likelihood of potentially possessing those attributes. So we made those a priority. It is our intent, Your Honor, it has always been, I want to make one thing clear, is to continue to try to work with landowners throughout this process. Those landowners have refused our access, so we've had to pursue this remedy, but it will continue regardless of the litigation to work with them. But to answer your question directly, as soon as we get an order from the federal court in connection with those initial properties, we are prepared, again, while our desire is to work with the landowners to give us voluntary access, we're prepared to immediately go into federal court and to pursue that remedy. Again, I would say and want to stress to you all, it is our preference is to work and to get voluntary access from those landowners. And we'll continue to try to get voluntary access. If we can't, is to pursue the remedies that are available to us at law.
So is it your response then that there's not a need for a site-specific study due to various calendar year and foliage-related issues for those remaining properties?
The vast majority of those properties, my understanding, don't possess the time of year restrictions that the other properties do. Instead of me getting over my ski tips on that, but my understanding is there may be some restrictions on wetlands and forest land delineations in certain of the counties, but I'll really have to defer to my permitting folks on that. But to your point, or to your general overarching question, it is our intent to pursue those, hopefully voluntarily, but if not, is to pursue a remedy through our court system.
Okay. Well, that's something we may have to follow up on once the court's order is issued. You mentioned earlier in your opening comment that the status of the proceeding in district court. The arguments have been made, post-briefs have been filed. An opinion from the court could come out, I guess, at any time. Do you have any expectations as to when that could occur?
Your Honor, I don't have an expectation other than the federal court has been very diligent in asking for briefs, and the time turnaround has been very quick. So it is our operating assumption that due to the fact that the court has handled those petitions rather expeditiously, that we should expect an order soon. It was certainly, I was hoping before today to be able to tell this commission that we've gotten a favorable determination. But that case is being very vigorously litigated by the landowners, and their very competent counsel have presented arguments to the court that it has to evaluate and weigh. But at the end of the day, we are expecting a decision soon. And of course, as we have already with our initial filing, we'll keep this commission and the parties, in this case, up to date on that, on the federal court's determination.
Okay, so In your comments earlier, then, you also noted that you envision a procedural schedule where this proceeding would occur, and at the same time, the proceeding in front of the district court would resolve itself in whichever way it does. At what point, and how does your proposed schedule look to incorporate the results of the federal court's proceeding? There doesn't appear to be a lot of openings in here to add on your additional survey results, sharing it with parties, providing additional information to the court as necessary, or excuse me, to the commission as necessary. How would you envision your schedule responding or reacting to what the federal court does?
Thank you for that question, Your Honor. What we're envisioning is as soon as we're given access, we're able to do the surveys that PPRP has requested, is to provide those to PPRP on a rolling basis and to the parties through the normal course of discovery. We did that in TransSource. The commission was able to develop a full procedural schedule that recognized that we were in the process of obtaining those surveys. And that will continue to do that through the course of this case. At the end of the day, I think it's important to just level set that those field surveys, while they are important, in fact, they're required for certain of our other permits, not for the CPCN, but for other permits. We've identified that in our application. Those surveys are for the purpose of validating the government information that's already underpinning our application. So it is our hope that at the end of the day that the field surveys will validate the already extensive information that we have accumulated and provided to this commission, and that will provide that throughout the course of the proceeding. I would note one thing, Your Honor, is in some instances, both in here and in other states, field surveys are actually conducted after the CPCN has been issued. So it is not unusual for a case to be evaluated based on field, let's say, desktop analysis and government source data to be later validated. It is our intent to get that information as soon as possible, and that we have every intent trying to do that. But what we like these, instead of the main point of contention is to wait till all of this data is accumulated and then commence the procedural schedule. We would advise strongly against that because of the urgency of the need for this line. So we would like those to run concurrently, provide the data once it's available, if it's available. Again, that issue is before the federal court, but if that data becomes available and we are authorized by the federal court to obtain it, then we will provide it to the parties on a rolling basis.
All right, thank you, Mr. Curran. I just have one other question regarding your proposed discovery procedures. You mentioned in your opening comments that discovery has already begun. You have a number of parties that have shared information already. In your proposed procedure, there is a compressing of time for sending responses and requesting information back, as well as serving objections. As of this point, have there been any challenges, problems, disputes that could have resulted in something that would have run afoul of the proposed procedures that you've already proposed here today? Is there anything you need to tell us about? And I guess I give you this opportunity before some of the other parties come on and to tell me something different.
No, Your Honor. To date, we have not run into any disputes or issues of concern in discovery. In fairness to your question, however, The only parties who have propounded discovery on us to date have been the PPRP and your technical staff. We've not received any request from any other parties to date. However, we are prepared, if we receive those discovery requests, to respond to them as outlined in our discovery procedures, recommendations.
Okay, thank you, Mr. Curran. Thank you, Mr. Chairman.
Commissioner Richard.
Thank you.
No questions, thank you.
Commissioner Barve.
No questions.
So I want to explore with you this operational date of June 1, 2027, and how it got determined. Was this based on discussions between your client and PJM after this project was selected, or was this date established by PJM and therefore your project was selected because you, quote, could meet that date? Or third alternative, did you say when you made the application to PJM that we could have this in service by this date?
Mr. Chairman, thank you for your question. My understanding, and of course, if I exhaust my level of knowledge on this, I'll ask Dr. Abu Salam from PJM to be able to validate or augment my comments. But my understanding is an open window in the 2022 RTEP. There were 3 open windows. The third open window was actually opened in early 2023, had identified a number of forecasted reliability violations to occur as soon as June of 2027. And those range from thermal violations on a number of facilities that serve Maryland and the region, as well as potential voltage violations. Those were identified in the open window when PJM sought solutions in early 2023 to those forecasted violations. And again, my understanding, and what I'll ask Dr. Abu Salam to confirm, is that when that open window occurred in early 2023 in identifying those violations and the date in which they were to occur, there were a number of developers that answered that solicitation. And PJM did its analysis throughout 2023, evaluating those projects through modeling and other efforts of the planning team, and ultimately selected the company. The company proposed its project to be in service in 2027 because that's the date that PJM identified the violations taking place. So I think to answer your question, it's a combination of both the identification by PJM in early 2023 of the violations and their significance and when they're to occur, as well as the developers' statement. Here, have a seat here. Your Honor, I do have Dr. Abu Salam here if you have questions about that process. But that's, I don't know, Doctor, if you've heard any of my answer to Chairman Hoover, but Chairman Hoover wanted to understand the combination of how the June 2027 in-service date was derived, whether that was something the developers selected or that was a process that occurred at PJM.
Yeah.
And actually, before you respond, just
Commissioners, this is Sandra McLemore on behalf of PPRP. Given the supplemental notice in this case where we were supposed to only address the procedural schedule, I would note an objection from PPRP to having
well, actually, let me do this. We're actually going to get to the other issues related to that, but I do want to find out an answer to this question about how this date got derived. So I'm actually going to deny the objection right now. I'll give you an opportunity at some point later today to opine on this and some other issues. But I want to get a better sense of how we got to this date, or the process for getting to that date. And for the individual from PJM, if you could identify yourself for the record before you respond to the question. Go ahead.
Yeah. Good morning, everyone. I'm not sure if my voice is...
And actually, I need you to either move closer or speak louder.
Yeah. Good morning, everyone. I'm just confirming that everyone can hear me.
Yeah.
Or should I speak a little bit louder?
A little louder, but we can generally hear you. And again, just identify yourself for the record. So.
Thank you very much. Thanks a lot. So this is Dr. Sami Abdul Salam. I'm with PGM Transmission Planning as the director of PGM Transmission Planning, and I did oversee the development of the 2022 Window 3 Regional Transmission Expansion Plan, out of which the need for this project was identified. To confirm what Mr. Max here highlighted, it is the responsibility of PGM to identify the in-service date or the needed date of the facility. And indeed, that date was stemming from observing violations in the PGM system, including in and around Maryland, and the areas as highlighted in my testimony as early as the summer of 2027, and hence the in-service date requirement for the enforcement was set to the June 2027 timeframe. Thank you.
Okay. Now, another issue, apart from the schedule, is this question of the completeness of the application. And, you know, the PPRP raised a number of questions about whether or not the information filed so far has, in fact, made the application complete. And I guess your response was that, in the applicant's view, you had provided enough information and the application was complete. But I guess my question is, were there any discussions between the applicant and PPRP of an attempt to try to cure any of these deficiencies that PPRP raised, or was it just your position that, you know, we've provided that information and, you know, it's time to move forward?
Your Honor, there is continuing dialogue between the applicant and PPRP to respond to their discovery and to address these deficiencies that they have, that they purport. Again, we just simply have a disagreement on what is required for completeness, right, based on your regulations, based on the Commission's regulations, and the wording and the requirements of your regulations. Nevertheless, we have every intention and commitment to PPRP, because we're aware of their, and spoken to them about this, we're aware of their very important statutory role in these proceedings. And they made it very clear to both us and to this commission that they want this field survey data, hence our efforts to get it for them. So, yes, we speak with PPRP and have every understanding of their role and their desire and request for this information, and we are doing our best to get it. We're just, our sole difference of opinion, quite frankly, is whether or not this information is required for completeness under your regulations. And it's nothing to do with both our combined desire to get the field survey data to them.
Okay, so let me now turn to PPRP, and I want you to go ahead and respond to any concerns you have about the information you've gotten so far and what you need to conduct your part of the process, and any comments you have on the proposed schedule from the applicant. So go ahead.
Thank you, Your Honor. First of all, with regard to the field level surveys, of course, PPRP completely disagrees with the applicant in this case. Field level surveys are required for CPCN in Maryland, particularly for a 67-mile greenfield. PPRP cannot carry out its obligation under 3305 of the Natural Resources article without having field level surveys of the right of way, and also without understanding the applicant's assessment and any changes in the initial right of way based on the assessment of the field level surveys. In addition, if you look at COMAR 2079-0402G, it requires that a topographic map is provided with regard to all the specific natural resource and environmental data. In data responses, the applicant has indicated that field work will be required to create a topographic map with elevation contours and heights as required in COMAR 2079-0402G. So therefore, we will need the field level surveys and their assessment and any revisions to the right of way based on that assessment before we can carry out our obligation under the statute. However, we are committed. They indicate that they provided a schedule for the entire case, but this schedule is both incomplete and speculative. It's incomplete because it doesn't have the field level surveys without which we can carry out our required assessment, and it is speculative until the applicant can commit to a date whereby it can provide field level surveys for the right of way and also its assessment and any revisions to the right of way based on its assessment. Now, PPRP is committed and can commit to a 6-month turnaround once we get this information. However, we don't have any date where they commit to providing it. Therefore, we can't provide a procedural schedule because we do not know where to start. However, if they would commit, for example, to providing the information by August 1, 2025, then we could provide ours within PPRP could provide its independent assessment and testimony and a reviewing state agency's conditions, recommended conditions, within 6 months. And then we could go from there in setting a procedural schedule. For example, for rebuttal, we could because there's so many different parties in this case, perhaps we could give 3 months and from the date that other parties provide their direct testimony to provide rebuttal, and then another 2 months to provide surrebuttal. However, in the event that they cannot provide that information on the date that they commit, we would request that we delay the schedule until that information is provided. Now, as for the bifurcation and trying to gain some types of efficiencies, which I do not understand, in the testimony and look at need first and then look at everything else. This type of approach would prohibit PPRP and the other parties from addressing the holistic issues in this case in a coordinated fashion. It would provide no efficiencies in timing. Also, it would be at a significant burden to PPRP, who has approximately 40 other CPCN cases at this time. And we have the same staff, consultants, and attorneys working on all of them. Therefore, we would need to be able to address all of the issues in one time once we obtain the information.
Okay.
That is all I have. I can answer questions also, since we had a witness in the event that you need to hear from Mr. Fred Kelly from the Power Plant Research Program. He is available, I believe, and on this virtual hearing.
Okay. So, Commissioner Richard.
Thank you, Mr. Chairman. And I just wanted to state for the record, given that my term of office ends in 3 weeks, it is my intention just to support the decisions made at this point. But I didn't want it to appear that I don't have questions, which I certainly do. But at this point, I will withhold on those questions.
Okay.
Thank you.
Appreciate that. Commissioner Barbe.
No questions.
Commissioner Linton.
No questions, Mr. Chairman.
Commissioner Suchman.
I have a few questions. Good morning, Ms. McLemore. You submitted your filing, noting the lack of completeness of the application on March 26th. PSEG responded, and then you responded to their response on April 11th. Is that correct?
Yes, Your Honor.
Okay. Between April 11th and today, have you heard from PSEG counsel about ways in which they could cure the deficiencies that you've identified? I mean, they've talked about the need to expedite consideration of it, and it would seem to me that curing the deficiencies that you've identified would help to move the process along. So have they spoken with you about what they could do to address your concerns?
Your Honor, we have served discovery on the applicant, and also we have been in discussions with them. Unfortunately, we need field survey level data in order to be able to carry out our assessment. They currently do not have access to this information. While we understand that they do not have access, it still is the truth that we cannot carry out our statutory obligations without it. And so therefore, we will need the field level survey. Having said that, we have had discussions of trying to figure out how we can work together to gain some efficiencies. And that's why I stated that we could do it in 6 months as opposed to the 9 months that we had requested previously. We had discussed perhaps doing it in a phased approach whereby they could provide information at the time they get it. And then we could start looking at like a third, because what they are currently looking at they've submitted to the court is approximately 1/3 of the right-of-way. That may gain some efficiencies, and we could then be able to expedite our review to 6 months. So we have been discussing that.
Okay. In terms of the alternatives, you wanted some additional data on that, and you identified that in the letter of deficiency. Has counsel for PSEG talked to you about ways in which they could cure that? I mean, I understand that they're proposing this kind of bifurcated, admittedly confusing process. But have they spoken to you about ways in which they could at least cure that aspect of the deficiency?
They have provided some data responses to that, but to be quite frank, we're trying to focus on the existing right-of-way currently and trying to get the information from that, because that is incredibly essential. The alternatives are also essential because in the event that there is an impact that they'll need to reassess their right-of-way, therefore we need that information to know if their assessment will have impacts and how to mitigate.
Okay, so from PPRP's perspective, you need the field studies first. That's the most important information that you need in order to be able to do your statutory responsibilities, which you can't do right now.
Yes, Your Honor.
Okay. In terms of the schedule, Mr. Curran said that he had provided you with his changed schedule, the modified schedule. Did he talk to you about ways that you could reach consensus on a schedule moving forward, or did he just send it to you as an FYI?
No, Your Honor. He provided it to us. Mr. Curran provided it to us. We reviewed it. I discussed it with my client, and we cannot. There is no way that we could carry out our statutory obligations under that schedule. I indicated that to Mr. Curran, and he was very polite, but there was no other way we could do it. We would need the field level surveys, And we would need 6 months approximately from the time we got those field level surveys, assessment, and any revisions to the right of way before we could provide our testimony, our independent project assessment and report, and the reviewing state agency's conditions.
Okay, and after you explained that to him, his reaction wasn't, okay, let's see if we can find an alternative schedule. What did he say? He said, we're just going to keep the schedule that we've proposed.
As always, Mr. Curran was very nice and respectful. However, I don't know if that would have been a possibility, given that they can't commit, they have not committed, they will not commit to a date in which they can provide the field level surveys.
Okay, okay. And if they can't do that, then you can't sort of discern a schedule that could possibly work for you to be able to get the things that you need to do done. You need the field studies in order to know how long it's going to take you to do the studies and then commit to a schedule.
Yes, Your Honor, and we understand that PJM would like this in the in-service date that PJM has proposed, as indicated, and because of that, we are committed to providing this in 6 months once we get this information.
Okay.
However, we have no idea of knowing when this information will be provided. And while we understand that PJM believes that there's a significant rush to get this in service because of the potential reliability concerns, they should have known that a 67-mile greenfield line in Maryland would need to have field level survey data before they could complete a CPCN.
So that they should have known that when they received project approval in December of 2023.
Yes, Your Honor, they should have known that, as explained by Stop PPRP in their response. They should have known that a 67-mile greenfield project could not be constructed in Maryland. You, the commission, could not do your due consideration without having information, field level survey data, their assessment of the field level survey data, and any revisions to the right of way, and then subsequently PPRP and reviewing state agencies' independent project assessment based on that information.
Okay, so I have one final question. In your experience representing PPRP, have you ever reviewed a greenfield project that was this long? Transmission.
No,
project.
Your Honor, I am not. I apologize.
Yeah, no, go ahead.
No, Your Honor. 67 miles is a very long greenfield line. As Mr. Kern has indicated, we did have Transource. Transource was smaller, and also in Transource, we were provided with a field level survey data book, or actually a commitment to when they would provide the information before we had a procedural schedule.
Okay.
Complete procedural schedule.
Okay, thank you.
So in your role in the process, you essentially coordinate the review by 7 different state agencies. And so I take it that the information from the field studies is the type of information that the particular agencies, MDE, DNR, the historical trust folks, that's what they use to make their assessments as to the impact, the environmental impacts, the social economic impacts that the line's going to cause in Maryland. Is that correct?
Yes, Your Honor.
Okay. And so...
And with that, I apologize.
Well, I think we're almost going to say the same things. But so essentially, they can't do what they need to do until they get these field studies, correct?
Yes, Your Honor. And Mr. Curran has indicated that the field level surveys, that they can do their regulatory actions after the CPCN. However, to determine what the impacts are, what's unmitigatable, and how we can mitigate other impacts, we need the field level surveys now, and we need to be able to coordinate with those reviewing state agencies.
And when you've done different projects, not so much transmission lines, but some of the energy facilities. It's that type of analysis and work that eventually leads to the list of recommendations that PPRP files with the commission to say this project can go forward as long as recommendations 1 through 20 or whatever they are adopted. Is that correct?
Yes, Your Honor. We would need that information in order to determine whether the impacts are so significant that it should not be built, or how those impacts can be mitigated so that it could be built. And we would need to be able to coordinate with the reviewing state agencies on those recommended conditions.
Okay. All right. Thank you. So I'm going to provide an opportunity for other parties to comment on both the schedule and this completeness issue. I guess my one thought is, if you don't necessarily have an opinion on this when I call upon you, don't feel compelled to say something. But if you have something you want to add, go ahead. So let me start with the Office of People's Counsel.
Thank you, Chair Hoover. So first, on the issue of bifurcation, OPC opposes PSEG's proposal to bifurcate review and testimony on the proposed project's grid effect and electrical need from review and testimony on the other factors in the law. OPC agrees with some of the other comments that you've heard and that were filed. The question of need cannot be completely abstracted from the other CPCN factors. As proposed by PSEG, the bifurcation doesn't seem to serve any purpose other than trying to pin down the parties to a position on need and grid effect without full consideration of the proposed project. Also, the bifurcation and the proposed schedule doesn't seem to result in the Commission being able to issue a final order any sooner than it would without the bifurcation. On the timeline, as has been mentioned, the proposed project is a greenfield project of unprecedented scale in Maryland, and it needs to be carefully considered along with all alternatives. All parties need a chance to do that. To speak to Commissioner Suchman's comments earlier regarding the timeline, to provide an example, in 2 rebuild transmission CPCNs pending for the Commission currently, testimony in those cases was scheduled 7 months after all parties were admitted. And those, again, were much smaller projects and rebuilds. Here, some parties were not even admitted to this case until this morning. So those parties and all parties would need a chance to review all the discovery and to sort of develop their positions as they're moving forward through this case so they can develop their testimony, and the timeline would need to do that. Also, on an issue that I don't believe is addressed by anyone, PSEG's proposed schedule only provides for 1 round of post-hearing briefs, and OPC requests that the Commission, in whatever final order it does on scheduling, would include a reply brief in that schedule as well.
Okay, Baltimore County.
Thank you. Baltimore County joins with the other parties in opposition to this rush schedule, particularly for such a long greenfield project. We haven't really seen anything like this before. And the county also has issues with resources. Its agencies have a lot of other projects and duties to the citizens of Baltimore County. And this shouldn't be a rushed process given the interest of the residents of Baltimore County and the protected areas within the county that will be affected by this project. The county urges the PSC not to set a schedule until the field study data is obtained. Thank you.
Okay, thank you. Carroll County.
Thank you, Mr. Chairman, and we would join in the comments of Baltimore County, as well as the Power Plant Research Program, and as well as the People's Council. We join them in opposing bifurcation. More fundamentally, it's clear that the field level data is foundational to the work of both the PPRP as well as the actual work of the Commission and the ensuring of a fair process here that has comprehensive data. On April the 11th, our Director of Planning from Carroll County wrote a detailed letter to the Commission outlining the importance of this field level data. He pointed out in the letter that about 400 acres of forestation are impacted by this proposal, including 128 acres in Carroll County. Additionally, it will be impossible for the commission to determine or the parties to effectively advocate about what the route is unless we know what the final route is as determined by the field level data and any changes the applicant makes. Moreover, there are significant issues that the 7 state agencies will weigh in. MDE will certainly weigh in on water quality, on wetlands mitigation, on air quality mitigation, and alike, and they cannot, as you just heard, perform their work without this field level data. Similarly, we cannot do work on forest stand delineation, specimen tree delineation, historic impacts, or other areas. This commission cannot meaningfully consider it, nor can the referring agencies provide their comments without this field level data. And frankly, we don't know, because the applicant doesn't know, when they're going to get this data, because ultimately that's in the hands of the federal court. So it would be premature to establish a schedule until this commission sees what the federal court is and then can have a meaningful understanding of when it would be realistic to get that data. Additionally, at that time, once the commission knows that, the commission should probably ask the PRPP to do an updated completeness assessment of the application, so that not only the issues of the field level studies are examined, but all the other deficiencies that were identified in their report to determine whether or not those have been addressed as well, as opposed to just simply accepting a proffer that we're answering questions and providing discovery here. I would close by saying that any urgency that's associated with this project is self-created. I think the commission's questions have drawn that out and made that clear. Additionally, any problems with getting the field level data could have been addressed by beginning that process years before and not filing formal actions not until this year. So for all these reasons, we would ask the commission to delay and not issue any scheduling order until we have an update on the field surveys, and also would ask the commission at the appropriate time to request an update from PRPP as to the completeness issues. Thank you.
Any questions? You okay? All right. Carroll County, or Frederick County.
Good morning, Your Honors. On behalf of Frederick County, I want to indicate that we do not support the bifurcation proffered by the applicant, and also note that the proposed schedules omits the required public hearings, and that bifurcation may result in the requirement for more than one public hearing in each jurisdiction. Frederick County also supports PPRP's position and renews the request made in ML 317710 that the PPRP's testimony, PAR, and recommended licensing conditions be provided in advance of the other interveners' testimony. I think there is a clear distinction between PPRP's function and in this proceedings, and the vast difference between the knowledge and abilities of the other interveners. And it is clear that having PPRP's reports prior to the other interveners filing their testimony will greatly streamline the process and enable the other group of interveners, including the counties and other individuals, to focus their testimony on the issues highlighted by PPRP and not have to guess as to what PPRP's position will be. So again, we do not support the bifurcation, and we request that the PPRP's deadlines, as has been proffered 6 months after completeness, that PPRP's information be filed prior to and sufficient time allowed for other interveners to file theirs. Thank you.
So let me just respond to one thing you raised, the issue about public hearings. It was actually our intention to set the dates for the public hearing after we set the procedural schedule for the evidentiary hearings, and then we were going to work with, quite frankly, the counties where the project's being proposed to set both the dates and the locations for the public hearings. Maryland Farm Bureau.
Good morning, and certainly I'm happy to go, but if I could make a suggestion, and that would be if Stop MPRP could go before.
Well, I'm just working down the list, so just go ahead, and if you have any comments to make right now, go ahead, and I will be getting to them, so don't worry.
Certainly, thank you. So good morning, commissioners. So as I mentioned, as we were entering appearances, we represent 6 farms in Maryland, so 4 commercial farms, sort of more traditional commercial farms, and 2 that have agritourism business, also Maryland Farm Bureau and the Land Preservation Trust. So for efficiency, I'm going to just go ahead and comment as to all of those. I would also note, Your Honor, that PSEG opposed a number of petitions to intervene here, including those of 2 of our clients, the Farm Bureau and Land Preservation Trust. So the idea that these entities have had many months in order to engage in this process would be incorrect, because they've only just been granted the right to intervene here, party status here, just very recently. We have a couple of points to raise more specifically with regard to the scheduling and completeness as well. But before I get to that, we would object to the proffered testimony that PSEG has attempted to enter into the record. I mean, certainly, again, this is beyond the scope of the order. We've had no meaningful opportunity to cross-examine this individual yet, and certainly will be doing so. And that testimony I would proffer will elicit that PJM received dozens of proposed responses regarding this in-service date, one of which was from PSEG, and PSEG promised to meet a deadline. And so without that promise to meet a deadline, obviously would not have been the contracting party as our proffer. So it seems that the idea of this testimony is a bit upside down. It wasn't like PJM came to PSEG and said, build this item. It was really the other way around, and we would suggest that the record will establish that on down the road in the case, certainly not today. We have 3 additional points with regard to the PPRP's recommendation on the lack of completeness, and a couple of the related matters. But before I get into 2 of those, I'd actually like to turn over the mic for a moment to my colleague, Randall Lutz, with regards to the field-based environmental studies.
Yes, I don't want to beat a dead horse, and I appreciate the opportunity to discuss this with your honors. But the field studies are absolutely necessary prior to moving forward with the other parts of this. I mean, the PPRP Council, the Assistant Attorney General, already emphasized this. I don't want to do any more, other than to say that there probably will be numerous times where they're going to encounter during the field studies impediments to their project. They're going to find challenges, some of which may stop the project dead in its tracks. And if they can be resolved, may require rerouting. It may be a minor rerouting, but it may require a rerouting, and which sets the whole schedule back. I mean, their ability to meet that deadline, I think, should have been questioned from the very beginning. I believe that PSEG actually knew they weren't going to be able to meet this deadline if they couldn't get access to the properties, which they have no right to do. So they should not be blaming the victims here. It's their own doing, as Mr. Maloney said, that they're in this jam as it is. And I would urge you to read an attachment to several of the petitions. It's a declaration from former Secretary of the Environment, Robert Summers, who explains in more detail the reason why field studies are necessary before proceeding with this. And I would urge you not to accept the bifurcation of this process.
Thank you. So two additional points then, Your Honors. So first, it is troubling that the manner in which PSEG has represented what's been proceeding in the federal court. So my colleague and I actually represent another group of landowners in that case, so I can speak directly to it. What is clear from the record in that case, which is pending, is that PSEG knew specifically as of over a year ago, in April 2024, that access would be a challenge. I mean, I think challenge may even have been their word. And they also knew from the TransSource experience, and TransSource utilizes the same counsel as PSEG, that environmental-based field studies would be required, and they've known this for a very long time. Yet, they did not, admittedly, even start attempting to request access from over 400 property owners until November 2024. And in that regard, they have been both brash and duplicitous. So they have been duplicitous, as we've pointed out in the federal case with regard to other clients, in that they initially proposed to those property owners, we only need limited survey access. We'll pay you $1,000, and it will be a very short-lived experience. Anybody, however, who contemplated agreeing to that access received this contract from PSEG, which really required 24/7, 365 access to their entire property, not just the proposed right-of-way, for years. And so unsurprisingly, with that being PSEG's approach, it was unconvincing to many of the property owners. So the idea that they have really engaged with the landowners is disputed. Also importantly, as PSEG has pointed out, they've sued fewer than a third of the property owners along the right-of-way. The idea that they picked properties based on selective fauna considerations, we have no idea what that would be because, of course, that is also not in the federal record other than their say-so. What does appear to be the case, however, is that they selected those property owners. They seek to obtain an access order from the federal court, and then they will rush to federal court and seek ex parte relief against the remaining property owners. Again, in that brashness approach. With regard to what they have asserted in that case, importantly, and what they have not mentioned here, is that in that case, PSEG has taken the position that the state of Maryland has conferred on PSEG, has already conferred, not in the future, but has already conferred on PSEG the right of eminent domain. And there is no explanation for it. There's no argument around it. There's no record supporting such a claim. Again, an issue before the federal court. But that is a central argument to their claim of access or claim for access in the federal court, is they claim they already have the right to do so. Now, if that were true, then why wait a year and a half in order to first really seek access? But that's what they did. With regard to, what happens next then, well, what if the federal court does not grant access? I mean, certainly PSEG has done nothing since letters in November, December, and some phone calls back then to seek access from all of the landowners along the right-of-way. They haven't done anything since then. Certainly they have not contacted any of our clients in this case since then in order to obtain access. And so we're very troubled by any representation that PSEG is working with the landowners to obtain access, and we dispute that assertion. With regard to what would happen then were this to be bifurcated, the record is important here, and that is the record in this case. So as mentioned previously, PSEG did not file this during all of 2024. They filed this application on the very last day, on New Year's Eve, 2024. It was about 2,000 pages long, and it was admittedly incomplete. Indeed, after this commission set the deadline for the petitions to intervene of February 17th, the last business day before that deadline, PSEG filed another 500 pages, so about 25% more in this case. So a supplement to their application. And there was no way that anybody who'd, of course, already petitioned to intervene, or anybody who was working on petitions to intervene, could have meaningfully reviewed that massive last-minute data dump by PSEG. Then, importantly, that wasn't the only time that PSEG has done this. In this case, on March 26th, with the incompleteness recommendation by PPRP, PSEG demanded a scheduling hearing and raised considerable arguments in that regard. Again, the commission set a deadline for comments to respond to PSEG's demand for completeness filing, and that deadline was April 11th. Once again, the day before that deadline, PSEG filed another substantive response. There is no way that anybody could have meaningfully reviewed their substantive last-minute response in order to meet the commission's deadline. But that also was not the last time. PSEG filed even more on April 28th without leave. And then, in fact, they filed something before this proceeding on Saturday, or I guess Friday, and they gave us notice on Saturday. The reason I point this out is because PSEG's proposed process here, in addition to having no efficiencies for the commission or for anybody really in this process other than PSEG, is it actually really will shift the burden. This would shift the burden from PSEG to a bunch of farmers in this case. We will undoubtedly receive, as the record already shows, hundreds and hundreds of pages of responses in the future on the eve of a deadline. And these short deadlines already are untenable. But were we to receive hundreds of pages yet again on the eve of, there simply is no way that anybody other than maybe PSEG with an army of lawyers could meaningfully respond. So we wanted to point that out to the commission as well as an additional ground for objecting to any of the proposal here. The application must be complete and the process must be allowed to play out in a reasoned fashion. What PSEG proposed is not. Thank you.
Any questions? Okay, stop MPRP.
Thank you, Your Honor. I don't have that much to add to what my colleague stated, and we had also filed a letter on June 9th, 2025, expressing our position, opposing bifurcation, and also opposing setting a schedule until the application is deemed complete. But I did want to point out a very practical example of PSEG's untimeliness. As I had indicated in the letter that STOP filed on June 9th, STOP intended to offer an alternative schedule to PSEG's in the unlikely event that the commission decided to go ahead and schedule the case. We attempted to coordinate with a couple of the other organizational interveners, and frankly, there simply wasn't enough time for even 3 or 4 of us to work together to come up with a coordinated response to what PSEG had submitted. And again, as PSEG acknowledged, this schedule was never shared with us in advance. The organizational interveners, as my colleague also pointed out, were basically playing catch up. We weren't granted intervention until a couple of weeks ago, so the idea that we could start discovery or begin to identify witnesses for the case when we didn't even know if we could function as full parties to the case is ridiculous. We don't have the resources to devote to a situation when we don't know if it's going to go forward. But if PSEG wants the organizational interveners and the other parties to cooperate, it has to act in a way that facilitates that. And to date, and again, as my colleague has pointed out, they have a pattern and practice of doing the exact opposite, of creating more chaos in the proceeding and making it difficult for the other parties to work together. In terms of some of the other issues, we oppose bifurcation. The issues are inextricably related. And the other point is, it's very odd that we're even talking about allowing this proceeding to be driven by an in-service date. Because to argue that the in-service date should drive this proceeding necessarily means, by implication, that this project is needed and that if it doesn't go into service on time, then grid reliability will be compromised. That's the core issue in this case. That's the issue before the commission, is whether this project is necessary and whether the absence of the project will lead to problems on the grid. So to take this foundational issue and use it as a driver for the schedule, in essence, prejudges the entire proceeding. And that's the other reason why we don't think that that PSEG's claims of urgency should drive this case. I think that covers, in terms of the schedule, as I said, and as others have mentioned, the deadlines that are set of a month to respond to witness testimony is completely inadequate. The parties would need at least 3 or 4 months to respond to the proposed testimony. And if that testimony is going to be supplemented at the last minute or amended at the last minute, we would need to restart those deadlines. And that's another issue too. There has to be some accountability for PSEG. So when PSEG submits something late, it can't just say, I'm sorry, let's move forward. We've got to start resetting deadlines. If they're going to, make a late filing on a 600-page late filing on visual impacts, then we should have reset the deadline for interventions. If they're going to update or supplement a pleading, we have to reset the deadline that the parties have to respond. That's the only way that this proceeding is going to work without prejudicing the rights of the parties. The only outstanding other issue that I have here is, so like I said, just to summarize, we support the position of the other parties in opposing bifurcation of the issues and also not setting a schedule until the information that PPRP requested has been provided. And we would also ask the commission, we have a pending MPRP has a pending motion for show cause related to PSEG's creation of a website for Maryland Energy Futures. It was a website that advocates for lower rates in Maryland by constructing more transmission. PSEG did not disclose that it was the sponsor of that site, and it also didn't disclose that as sponsor of the site, it happened to coincidentally have an application for transmission pending before the commission. I want to make clear that we do not oppose PSEG's right to advocate for this project however it wants to in whatever manner, but that advocacy has to be transparent and it has to be open so that the public isn't misled. So we think it's important to get some kind of ruling or some kind of statement from the commission on our pending motion to show cause and an admonishment to PSEG that in the future it needs to be forthcoming about its involvement with these different types of political campaigns to advance its position, to do it in a way that's not misleading. And I have no further points. Thank you for entertaining these arguments today.
So, any questions? Well, actually, Commissioner Sussman.
Well, I can still say good morning since we have 4 minutes left. Ms. Sullivan, how are you? Counsel for PSEG suggested that there had been some discovery in this proceeding and then clarified that he had received questions from PPRP related to the deficiency of the application. So I just wanted to get clarity from you. Have you submitted any discovery requests to PSEG?
We have not, because we were not aware until I think roughly about May 25th or thereabouts that we were going to be interveners. And we don't have the resources to draft speculative data requests. And in any event, even if we had, we wouldn't have been able to serve them until May. So we have not served any discovery at this time for that reason, because our motion to intervene was opposed, which is highly unusual. And of course, our intervention was granted because we represent 1,300 landowners who are impacted by the project. But it's, again, that type of activity that wastes the party's time and that causes delay. That was all caused by PSEG. But again, to answer the question, no, we have not engaged discovery yet.
Okay, and since your application to intervene was approved, have you seen any discovery that had been proffered by other parties in the proceeding? Any discovery responses from PSEG?
PPRP had shared some of its discovery requests and responses with me because we have, unlike PSEG, attempted to coordinate with all of the parties in the case. And so PPRP very generously shared some of the discovery responses. And I believe some discovery responses were also appended to some of PPRP's filings. But we haven't, and I may have, it's possible I may have seen some requests by staff, but otherwise we haven't seen the discovery requests. Now, I will note that within the past couple of days, PSEG did give the parties access to the discovery portal, and I have not yet set up a portal site. So it's possible that those requests and those responses are in that portal, and I have not checked them. So that would be something that's on me. But up until then, we had not received any of the information from PSEG.
Okay, so I'm just looking at their proposed schedule, and the first event would be direct testimony filed on August 1st, and then in parentheses, 7 months post application filing, which would suggest, if you weren't paying attention to the proceeding, that there had been 7 months of activity in order to support the filing of direct testimony. So here we are in June. Based on the limited amount of discovery that you've seen, is there anything close to sufficient base of information for you to be able to prepare direct testimony?
Well, no, because we haven't engaged discovery ourselves. I mean, with all due respect to staff, PPRP and OPC, we will certainly take advantage of all of the very robust discovery they've served already. But we have other issues that we want to pursue in this case. We have witnesses. We're beginning to identify witnesses who are going to put testimony together, and we need to coordinate with them and issue and proffer our own discovery requests. So regardless of what's been out there already, that doesn't give us nearly enough time to engage and initiate our own discovery, have our witnesses review it and put together testimony. I mean, we would need, at a minimum, if the schedule were set today, we would need a minimum of 9 months to be able to do all of that and put our direct testimony together.
Okay, but the counsel for PSEG had suggested that there be robust consideration. So I guess based on what discovery has been proffered, would you suggest that that's anything near robust, what you've seen so far?
No, absolutely not. Most of the responses just direct the proponent of the discovery to information in the testimony. I can read the testimony myself. What I need are the documents that the testimony relied on. What I need are explanations of what happened at board meetings and other things behind the scenes that motivated or led to some of the applicant's decisions. None of that information has been provided. It's basically just an annotation of, here's where our witness talks about need. Here's where our witness talks about the PJM deadline. I mean, it was what I have seen has been very superficial. And I mean, with all due respect to the parties, they may not have had a chance. They may intend to follow up and seek more information, but they're also asking from a different perspective. But from what I've seen, that's kind of been the nature of the discovery.
Okay, thank you. That's all I have.
Commissioner,
thank you.
Thank you, Mr. Chairman. Commissioner Suchman has already answered my question. It's all right. It's all right.
Okay, so I actually want to turn to staff counsel, but before I do, I want to give anyone else who's participating today a chance to comment on this, although I would like the comments to be focused solely on this issue of the completeness of the application vis-a-vis the field studies and the proposed schedules. I don't want, and this is not the put the pro se participants on the spot, but we're not going to be listening today for comments on the substance of the line and its proposed route. So if you have issues you want to raise related to this issue of the completeness of the application and the proposed schedule by the applicant, and you want to make a comment, just let me know right now.
I have a comment.
Okay, go ahead. First,
This is-
identify yourself and then go ahead.
This is Jennifer Teeter. In PSEG's application, they mention in the visually sensitive resource table major impact to properties that are on the National Historic Register and other registered significant historic properties on the line. And I know that the Maryland Historic Trust and the National Historic Trust, per Section 106 of the National Historic Preservation Act, will want time to review the field study data in its completeness in order to weigh in on these projects. Thank you.
Okay, thank you. Anyone else?
Yes, Jennifer Wazensky.
Yes, go ahead.
Not sure if you can hear me.
Sure, yeah, go ahead.
Yes. Hi, again, good morning or good afternoon at this point. I'm speaking on behalf of River Valley Ranch and Peter and John Radio Fellowship. And just want to echo the comments of my colleagues and also to the counties whose remarks and positions I'm hearing for the first time today. But I thought there's significant value added to the remarks that both Baltimore County and Carroll County have made with respect to the value of having further evaluation or I guess reporting back by PPRP following any alleged completeness of the application. RVR is one of the organizations that has been required to both respond in this forum and also in federal court, and finds itself sort of in the position of a party that highlights a lot of the issues that are driving, I think, the frustration of many of the interveners in this case. RVR finds itself within maybe a couple of thousand feet of an existing right-of-way that borders the northern edge of its property, and yet PSEG has determined to dip down out of that right-of-way just in time to hit our property. And with it, a number of sensitive species and forested areas that sensitive species territory and forested areas that this project could have avoided by going through an existing right-of-way. And so I think it just highlights the sort of self-inflicted nature, the urgency that's created here. They've determined to take a greenfield approach to this project, and that is what is adding complication and possible impossibility to completing what they want to do. And the answer is not to rush the process. The answer is not to allow them to drip feed information that forces parties with limited resources to respond rapidly and possibly incompletely and without optimal coordination with others. This process needs to play out, and it needs to recognize that many of the interveners in this case, RVR included, represent other important aspects of the public interest here. These are property owners that are feeding Maryland families through their agricultural projects. In our case, we are providing unique and increasingly rare outdoor recreational opportunities to youth throughout Central Maryland and beyond. These are things that won't be recreated if this project is rushed through and hastily approved. And so I'll yield back. I don't want to beat that dead horse again. We do actually own a ranch after all, but I wanted to make those points and just highlight that for you today. So thank you.
Okay. Anyone else?
Yes, thank you. Mike Hinkle again for Dell's Generation Farms, Matthew Dell, and Francis and Marion Dell. And my clients also are not only parties to this proceeding, but also parties in the federal court action. I won't repeat all of the arguments and comments made today by other counsel, but for the record, I would like to note that my clients also oppose PSE&G's proposed schedule and its request for bifurcation for the reasons stated. Thank you.
Okay.
I'm getting out of here.
Okay.
Why?
My name is Lisa Wright. I would just like to say really quickly that I echo the thoughts in opposition of the proposed timeline and would like to additionally echo the disadvantage that it creates for those trying to respond, especially those who are pro se.
Okay. All right. Thank you. right,
They
so,
think they're October 18th, not November 1st.
okay, let me turn now to staff council, get their thoughts on this.
Thank you, Chair Hoover. Staff concurs with all of the parties here that oppose the bifurcation of the case. In general, as is normal in CPCN cases, PPRP has the bulk of the issues, and we tend to defer to them on scheduling needs, and we will do that here as well. Their judgment on the issue of what they need in order to accomplish their statutory goals is paramount on that. But I do note, with respect to bifurcation, we have specific reason to oppose that. The bifurcation, as PSEG has proposed it, essentially calls for testimony on the reliability and stability of the grid issues and the need for the project to be filed within 2 months of now. And those issues are specifically staff's issues in this case. Those are the issues that we are required under statute to offer our opinions on. And frankly, we do not want to have them set aside into a separate cubbyhole and have to make our pronouncements and our opinions on those issues public in a completely separate stage of the proceeding. We would very much prefer to do that when all of the rest of the issues are being addressed. Beyond that, it does seem very difficult to contemplate setting a procedural schedule in a case where a lot of the most basic information that's needed to decide the case, we do not even know if the company will be able to obtain that information, let alone when. So at this point, we would argue that it remains premature to establish a full procedural schedule. And I will leave it at that, but I am certainly willing to answer any questions the Commission has.
All right, let me start, and I just want to get a better sense of what the sort of normal practice and routine is. In rate proceedings, it strikes me that staff tends to take the lead in working with the company proposing the rate increase, Office of People's Counsel, and any other interveners for determining the schedule. Based on what you said earlier, in the CPCN cases, does that role shift the PPRP just because of their unique nature in this process?
I think we still have a kind of mediating role in the process of developing a schedule, but yes, I mean, we will largely defer to PPRP because they do have the bulk of the issues in the case. And, they have such a heavy lift, especially in a case as large as this one.
Okay. And did you have any discussions with the applicant regarding their proposed schedule, or did they just show it to you and say, here it is?
Pretty much the latter, Commissioner. I mean, they haven't indicated that they would be closed to receiving further feedback from us or information from us, but basically, they presented it to us to react to, and we really haven't had a chance to react to the updated schedule.
Okay.
But in any case, as I said, we do not favor the bifurcation they are suggesting.
I understand. So any other questions for staff? Okay, so let me turn back to the applicant. I realize you got a long list of stuff you can potentially respond to, but go ahead and
Thank you, Your Honor. Can you hear me?
a little bit. Again, just
Okay.
use your outside voice, I guess.
My voice up. And I just want to reiterate, one, to thank the Commission again for scheduling today's pre-hearing conference and having an opportunity to hear your questions and your concerns, as well as to hear from us. Has been very helpful today, and to hear from the other parties who we look forward to continuing to work with through the discovery and the ultimately through the submission of testimony and briefing in the case. The only thing that I would reiterate that was in our pleadings before the commission is that it is important, whatever the decision, to have a full procedural schedule. That is what you did in TransSource, setting deadlines and the status reports that are in that case. We would, while that is a completely different situation than this one, in that that was a market efficiency project with a different in-service date, it was instructive to have a full procedural schedule that allowed the parties, allowed the developer, and importantly, to have PJM the knowledge of when this project will be fully considered and hopefully approved by the commission. The only other legal issue we would again point in your direction is your own regulation. And while there's been healthy discussion today that field surveys are required for completeness, I would direct your attention to COMAR 2079-0110 that provides that an application for a CPCN may not be deemed incomplete for failure to provide information that is not required by COMAR 2070-0106. And it is clear that field surveys are in no way mentioned anywhere in that provision. In fact, you review our submission and our exhibits, we go through painstakingly how we met and are meeting each one of your COMAR requirements for filing. Having said that, as you've also heard today, PSEG is not in control of the ability to obtain field surveys. That is not a right that we currently have until the federal court provides us with that authority as we have sought. So the suggestion that somehow our application was deficient, that we neglected a requirement, that we are ignoring a requirement is simply not the case. We don't have that information because we were being denied access to it. Despite what you've heard from some of the council here, I can represent that it is our intention to work with landowners. This is a utility. We are in the business of providing a public service. And this client will work with the landowners and their council. Hopefully, after today, their council will consult with their clients and grant us access to these properties so that the very field surveys that they have demanded from us can be conducted. That is up to the landowners and their council, who you've heard from today, who would hopefully instruct them to provide us with that access. But again, we have provided to you, your honors, a full application. We will work and will continue to work with the parties, and that we hope that you provide us with a schedule that gives us the opportunity to meet this date, because it is about providing reliable service to the state of Maryland and to this region. Obviously, we are available to answer any additional questions, but would direct you to that, and would humbly request that you provide us with a schedule that addresses the in-service date, but also provides the party a meaningful opportunity to respond to our application, which they have had since December of this year. Thank you, Your Honor.
So, any questions? Okay, so what we're going to do is actually take this matter under advisement. And what that means is that we are going to, go back and discuss this amongst ourselves with our commission staff and lawyers and issue an order on the way forward, either adopting a schedule or creating a process for creating a schedule in this proceeding based on all the information we've been provided today, and make a ruling on the question of whether or not the application in its present state is in fact complete. We will get that order out as soon as possible, and that'll be the next step in this process. So I can't give you an exact date when we're going to do it, but it'll be sooner rather than later. And unless there's any other matters, I guess